On behalf of Richard Kaplan, I'd like to welcome all of you to Books and Books here in Coral Gables. Tonight, Books and Books and Miami Book Fair present an evening with Jorge L. Contreras and Daniel B. Ravicher in conversation with Miami Lit Podcast as they discuss the Genome Defense inside the epic legal battle to determine who owns your DNA. In this riveting, behind-the-scenes courtroom drama, a brilliant legal team battles corporate greed and government overreach for our fundamental right to control our genes. I'd like to welcome Mrs. Jenny Ponce to welcome our speakers.
Thank you.
Woo!
I want to be able to see your faces.
You're not missing much.
That's not something lawyers hear often.
So, hi everyone. My name is Jenny Ponce. I'm the host of my Lit Podcast. I want to thank you all so much for being here in person. This is a first for us, and we're very excited. And we are even more excited to be able to be in this location in Books and Books in Coral Gables, which is so historical for Miami and books, and for me personally and George. We remember coming here and enjoying, gaining our love for books here. So it's so nice to be able to now experience it this way. Just a formal introduction on our panel today. Jorge Contreras, or George, received his law degree from Harvard and teaches intellectual property, science policy, and the law and ethics of genetics at the University of Utah, and has served on high-level government advisory committees. His articles have appeared in Science, Nature, Harvard Journal of Law and Technology, among others, and many, many more. And he is the author of the Genome Defense, which you are all here to learn more about. And our gentleman over there, Dan Ravicher, is a partner.
Zeisler.
Thank you. Zeisler, where he represents clients in business and technology-related litigation transactions, which he's done since the dot-com boom. Dan's litigation experience includes representing intellectual property rights holders and accused infringers in cases across the country involving pharmaceuticals, biotechnology, medical devices, semiconductors, telecommunications, software, consumer electronics, and other technologies. He won the 2013 Supreme Court case that held human genes cannot be patented, which is the subject of today's discussion, the book. Before we get started, we have another special announcement. It's a special day for someone in the audience. George?
Yeah, well, so one of the people I dedicated the book to my parents, and one of them is here today, celebrating his 80th birthday. So, the reason the dedication reads as it does is because one of the things that got me to love science and technology as a kid was the model rocketry. Dad took us out to and chased a lot of rockets around Tamiami Park as crazy little kids. So anyway, thanks and welcome.
My pleasure, George.
Well, with that, let's go ahead and get started. Let's dive in. Let's talk before we arrive at this crazy tale that you tell us. When did you all decide that writing and law was going to be it for you?
I go first. So I've always loved writing, and first reading, and then writing came after that. And when I went to college, I was studying engineering, and in the middle of that, realized what I really wanted to do was not be an engineer, but do something that I could, spend more time writing, and so I became a lawyer. And then I realized after being a lawyer for a number of years that, being a law professor seems even better, because then I can write about really anything that I want to, not just what my clients will pay me to do. Dan can tell you about that side of life. And it's been wonderful. It's a wonderful freedom, and really something that took me quite a while to get to, but have been very happy with.
Yeah, and my parents were both mathematically and scientifically trained, and so I expected to be an engineer and went to college to be an engineer. But I didn't know it at the time. In third grade, we did some government moot court thing, and I was somehow the lawyer, and people said I should be a lawyer, but I brushed it off. And then in law school, my father was an engineer, and he said once you become an engineer, for a while you become a manager, and you stop doing engineering, you start becoming a business person. And that didn't sound so interesting, so I thought I could go to law school, but I didn't know if I had the right background. And a friend I knew was a lawyer and said, no, you could take your engineering degree and get a law degree, combine the two, and become what's called a patent attorney. And the way he put it, because he was a plaintiff's lawyer, said, you'll make lots of money. It's a very, to become a registered
That's important.
Yeah, there's a separate bar you have to take to become a registered patent attorney, and they give you a number chronologically. So there's only been about 70,000 patent attorneys in the history of the United States. And my number starts with a 4. That kind of tells you how old I am. So I love learning about and staying current with technology. Like all those things you read that I deal with are all technologies that my clients are developing, working on, finishing. Some of them are products in the marketplace. One of my big clients decades ago was the Sonicare toothbrush. If anybody uses it, litigated patents over motorized toothbrushes. Hopefully no one in this room is a customer of one of my other clients dealing with stents and your hearts and angioplasties and all that kind of stuff, and leading to this case. So I kind of love, if I was just a lawyer, I wouldn't love it as much as I do being a technology kind of lawyer.
Right. That's so interesting. There are so many components to the case that we're going to be diving into in this book. In your opinion, what makes this case so special?
So this case really is unique in the world of patent cases. So I'm a law professor. I was a practicing lawyer, then became a law professor, and I follow patent law, have throughout my whole career. And patent cases are often very technical, and even important Supreme Court cases involve things like automobile brakes and technology that aren't very interesting to the ordinary person. This case was really remarkable because the technology at stake was something that affects every single person, right? The genes that every single person has. And it also involved people from all different walks of life, not just lawyers and not just scientists, but ordinary people, patients, who were affected by the patents on these particular genes. And, I've been to the Supreme Court, I've heard Supreme Court arguments. This is the only patent case that I'm aware of where there were demonstrators on the steps of the Supreme Court, where you've got A-list celebrities like Angelina Jolie and Michael Crichton weighing in on a patent law case. It's crazy. And so it's so unique in that way that I really thought it was worth writing about.
Yeah, the third thing that I've really been happy to be able to do a lot of my work on is public service. There's kind of, when some people feel that they've been given certain talents and blessings, that it's more rewarding to help others. And so I had practiced law after law school for a few years, and then in what one of my partners at the time said, you're either really courageous or really stupid, I quit my law firm job to start a nonprofit organization to represent the public's interest in the patent system. And the first problem with that is most people have no idea how the patent system impacts your life. I can guarantee you every single person in this room is severely impacted by the patent system. And the patent system has been created and marketed in a way to make you think it doesn't impact you. So every time you have to get a pharmaceutical, every time you get a medical device, every time you want to communicate with someone, every time you want to fly somewhere, drive somewhere, do any voting, there are patents on voting. There are patents on the abortion pills, the safest way to have an abortion on that pill. There were patents on it. There was controversy over who would own that patent. And could certain people own that patent and stop people from getting a legal, safe pill? Are there patents on voting machines so that only one company can have voting? More than half of the patents issued today, which grants the owner of the patent the right to stop an American from doing something, are issued to foreign companies. 7 of the top 10 recipients of the American patents are foreign companies, Chinese companies, Japanese companies, German companies. So we're giving these companies the right to come in and either deny us the right to do what's covered by the patent or kick out all the competitors and charge us a super high price. So that's the first thing I wanted to address in my nonprofit. And so when this case came along, it was just one that obviously struck a chord as being, this is a case where the public is being harmed because patents are being granted to one company so that they're the only company who can tell you if you have a genetic predisposition for a certain disease such that that predisposition would support a doctor making prescriptive remedies or recommendations to you. Should you have a prophylactic mastectomy? Should you have prophylactic procedures to save your life? Well, we don't know because one company has a patent on the BRCA test and it's too expensive or I can't access it. So this case was pretty clearly one that fell within the mission of the nonprofit I started.
That's incredible. It sounds like a dystopian novel that you guys witnessed and lived through. Can you tell us in layman terms, what is patent law?
No. But in all seriousness, I mean, that's what this book is about, right? It seems like a boring and complicated field, and in many ways it is. But it affects so many people, and it is not that complicated, really, at heart, right? So the patent law rewards inventors. If you invent something, then under the law as it is today, you can apply for a patent, and if you get the patent, then for 20 years, you'll be the only one in the United States allowed to make, use, or sell whatever that invention is. And why do we do that? Well, it's because this encourages people to make inventions, right? Sometimes it's very expensive to put together the materials and the testing to make an invention. And if you spend a lot of money, say, hundreds of millions of dollars, which is what the pharmaceutical industry claims it costs to bring a new drug to market. You spend those hundreds of millions of dollars. If you do that and then create your drug, and the next day other people can copy it and ride off of the invention and development you did, that wouldn't be fair, and you wouldn't bother to spend that hundreds of millions of dollars, right? So we want to encourage people to innovate, and we do that by rewarding them with this period of exclusivity where they're the only ones who are allowed to make the invention. And that's what the patent law is. And we grant patents on anything that is an invention. And this is one of the key questions about this case, like what's an invention really? But whether it's a light bulb or a new type of plow or an automobile tire, all these different inventions, we want people to make them. So we give them this period of time that they're the only ones who are allowed to do it. That's it.
Yeah, I got it. I think
it's simple. It's not that complicated.
In my opinion, there's only one moral legitimacy for any law. So law by definition restricts what we can do. Bad, in my opinion, not to get political. So by definition, laws are bad. Okay? So what's a moral legitimate justification for law? And the only one that I've come to in my heart and mind is to solve the collective action problem or game theory. Right? Why do we have to have a speed limit? Why can't we just let people drive as fast as they want? Because collectively, if we all drive as fast as we want, we'd suffer a net loss to society through increased accidents and gas waste and all this. So there's a collective, we have to bind ourselves to the mast of a law in order to collectively reap the efficiency gains that would be lost if we were just allowed to do what we want. Why is murder illegal? Well, some people would say moral, religious. But murder is bad because people aren't going to feel free to leave their house and be productive citizens to create a more efficient society. So the collective action problem meant to be solved by patents is exactly what George said, which is we need to create incentives for people to invest, to develop inventions, and if someone else can just copycat them overnight, then there's not going to be that incentive to do that investment, that fixed cost that's required to come up with an invention. Because inventions require a fixed cost and then a marginal cost. And with pharmaceuticals, for example, the marginal cost of making a copycat pill is very low. It's that first pill that costs millions of dollars, right? The second, third, fourth pill all cost 5 cents. So that's why we have to have these patent laws.
So how can someone own our DNA?
Yeah, so that's sort of the central question of the book. It seems kind of ridiculous, right?
Yeah.
When you first say it. And if you just sprang this out of thin air, today, it would be ridiculous. But it's one of these things that over the years, this grew by little increments, and it seemed perfectly reasonable to most of the people who were involved. So how did it all get started? Well, you could always patent an invention of some kind, a new plow or a new wagon wheel or what have you. In 1980, there was a famous Supreme Court case that involved a guy named a scientist for an oil company, it was actually General Electric, named Anand Chakrabarty, and he genetically modified a bacterium, inserted in this bacterium's DNA a chain of new DNA that allowed the bacterium to be attracted to petrochemicals, like to oil. And so that if you spray it on an oil spill out in the Gulf or out in the ocean, it's going to break down the oil. And we do this, right? This is what we do. When Deepwater Horizon and all of these oil spills happen, helicopters fly over, they spray this stuff on, and it helps break down the oil. It's not perfect, but it works. This guy invented it in the 70s. And there was a real question, could he patent it because the bacterium's a living organism? And there was a big debate about this. There were a lot of moral objections, religious objections, like you shouldn't be able to patent a living thing. But the Supreme Court ruled in a 5-4 decision, this was a highly contested decision, that yes, General Electric could get this patent on the bacterium. So in 1980, we said, okay, living organisms, you can get a patent if you invent them, right? And so then this leads to more and more things getting patented. And about this time in the 80s, we're starting to be able to sequence DNA, including human DNA, and researchers are able to start to find chunks of our DNA that do things, that have some effect on diseases. So if you have certain variants in your DNA, you're more likely to get cystic fibrosis, right? Or hemophilia, or you name it, lots of different hereditary diseases. And to do that, they had to take the DNA out of the human body, isolate it, purify it, make millions of copies. And that thing that they created, that isolated DNA chain, they convinced the patent office that it didn't look like the DNA in your body, in your cells, right? Because it was broken out, it was isolated, it was purified, and it was something different. And the patent office was persuaded. They said, yeah, okay, we agree. This DNA that you took out of the cell that has something to do with cystic fibrosis or breast cancer, in this case, it's something different that's in the body. So you invented it. So it's like the bacterium, you can get a patent on it. And that just kept snowballing, right? More and more of these genes got discovered. So by 2005, these MIT researchers counted, and it looked like 20% of all the human genes that we knew at that time were patented in some way. And that's when things got interesting, and this case started to percolate. But and it was incremental, very gradual steps that led to a result that today seems just weird.
Yeah, so George gives you the play-by-play excellently, and let me just give you some of the political atmospherics. So in the 80s, we had the boom of the software and biotechnology industries, and they gained so much political clout so quickly that in the early 1980s, we had 3 huge changes to patent law. One was Congress passed a law in the early 1980s, right around the time of these Supreme Court decisions, saying that government-funded research could be exclusively owned by companies. So we all pay taxes. Some of our taxes go to NIH or other government entities, which then give grants to researchers at the University of Miami or FIU. They do research. If they invent something, those inventions can be patented and then owned or licensed exclusively to a corporation. And that's a way where corporations are being subsidized by the taxpayer. That was one law. The second law was usually cases in our legal system get appealed to a court of appeals in the geographic region in which the trial court exists. Well, patent holders were losing too often. So they went to Congress and they literally bought themselves a home court advantage. And Congress created out of whole cloth a brand new court of appeals, which would be the exclusive court of appeals that would hear all patent cases. Overnight, that court of appeals issued decision after decision after decision in favor of patent holders, patent holders, patent holders. We then had a third law passed in the early 1980s, which gave pharmaceutical companies a guaranteed number of years of monopoly if they came up with a new drug. Guaranteed, and they were automatically entitled to injunctions against generic drug makers. So there was a lot of political dynamics. One of the other things, we had a patent office forever, but patent office, like most agencies, get captured by the people that frequent them. And in fact, the patent office used to have a sign that say, "We're here to service our customers." And their customers were not the public. The customers were people applying for patents.
Right.
And so the United States Patent Office had a granting rate of about 90%, which was 50% higher than Japan, Germany, and other places in the world, because we just had a let's grant patents, grant patent, grant patent kind of philosophy.
Yeah, that's a fascinating point, right? If you look at the Patent Office's publications, that they talk about the Patent Office and patents as though they're a factory, right? They talk about their throughput and their production rate, and like there are 9,000 individual examiners, right? These are the people who examine the patent applications. They each have, it's like a worker on an automobile assembly line. They've each got their own rate. They've got a quota. They get paid based on like how many applications they push through, and it really was like a production line as opposed to a thoughtful government service that's being performed here.
Yeah, trivia question, you're all going to know the answer. There's only one federal agency that's profitable. Which federal agency is profitable? The United States Patent and Trademark Office. About 10% of its revenues gets taken from Congress and used to fund pork projects. Another thing you may not know, the Patent Office makes 10 times more money when they grant a patent than if they reject it. They're literally incentivized financially to grant patents because they charge a very low fee to apply for a patent. And then after they've said, okay, we will grant it to you, you just have to pay this large bill, just pay this large bill and we'll issue you the patent that we've told you scientifically you deserve. So we have misincentives all over the place for bad behavior.
Wow, I did not know that. That's crazy.
You're not supposed to know. Most patent systems don't want you to know. They want you to think the patent system is boring, and they want you to leave the patent system alone.
You heard it here.
Oh my gosh. Yeah, I'm dumbfounded right now. Even though I read the book and I should not be surprised. Dan, what did you first think when you became involved with the case? What was your reaction?
Well, so as George describes the book, which I won't spoil too much, so I was actually working on starting a challenge to some gene patent cases on my own independently. So as the case was filed, my nonprofit and the ACLU were co-counsel. We came to an agreement where we work on it together. They had certain capacities and resources, and my nonprofit had certain capacities and resources, namely we were the patent lawyers on the case. And the ACLU had great marketing, great Supreme Court litigators. There's not a lot of patent litigators who have Supreme Court experience. So we thought that combining the ACLU with my nonprofit would be a great merger of talents and would be something that'd be necessary to take on what we expect to be the whole industry. But prior to getting to that relationship, which as George describes, this was not a non-controversial decision for the ACLU. It was also not a non-controversial. I was employed at the time teaching at Cardozo Law School. And when we filed the case, some of the members of the board of Cardozo Law School called up and told the dean to fire me. Because how could Cardozo Law School be involved in trying to destroy the biotechnology industry by taking down gene patents? So when I first got involved, it was through a scientist named Chris Mason, who's this genius guy and also the most like low-key scientist. I'm sure he's going to win some major prizes in the future. You may have heard there was some crazy person that wanted to go in the New York City subway system and scrape for all the DNA they could find and see what diseases and things existed. Yeah. And the transit system tried to kick him out. Fortunately, because I had represented the New York City subway when they had been sued for patent infringement, yes, subways can infringe patents, as I was telling you about earlier, transportation. I knew them, and so we got a pass so Chris could go ahead. So Chris and I were talking about this. He then knew Tanya, who's probably the star of the whole show. The non-lawyer scientist at the ACLU hired Tanya. And so we met Tanya, we met Chris, and then we said, hey, we all want to work on this together. This is serendipity or whatever you want to call it. You know, it's meant to be.
That's such a cool behind the scenes.
Yeah.
I mean, it's not cool, but you know what I'm saying. It's so interesting to hear that side of the story. And I'm sure it's safe to say on behalf of everybody that we're glad that you all decided to take this on.
That's very kind.
Yeah.
You're blessed to do it. It's fun, right?
Not from where I'm standing, but I'll take your word for it. It seems unreal that patents had been issued for so long, as you said, since the early 80s, and no one had questioned it, or it hadn't been a problem. How could it have, I mean, you touched upon it earlier a little bit, but how could it have gone on for so long?
So one thing that you really come to realize in this landscape is that there were very few people who were being financially harmed by these patents who had any voice in the system, right? So even as a law student, I worked for a law professor, and we worked on one of these gene patenting litigations, but they're always between two big companies, right? Amgen and Genetics Institute, fighting over whether this company's patent is better than that company's patent, like whose preempts the other, which one infringes the other. So there was a lot of litigation going on over these patents, but nobody had a financial incentive to challenge the whole system. Say, well, and why do we have these patents in the first place, right? The patent office is granting them. And so it's always a question, well, mine is better than yours, or, mine is preempts yours, or whatever. Who's going to win? Who's going to be able to take this this royalty, this rent from the public? There was nobody literally looking at this system from a public standpoint, saying that, well, actually, none of you should have these patents. And this went on for literally 20 years until this coalition came together, in the mid to late 2000s to say, wait a second, what's going on here? How are we allowing this to happen?
Very interesting. What about the ethics and morality of DNA testing? Did that go into play at all?
So this was an important aspect of the whole case. So the book is about, we talk about the patent system and whatnot, but the way our litigation system works in this country, you have to challenge like a particular company. You sue a particular company, or you don't sue the system. You can go to Congress and try to get the system changed, and people did try to do that, but it didn't work. So to change something by litigation, you've got to find a defendant and sue them. And so the defendant in this case is a company who had patents covering the BRCA genes, BRCA1, BRCA2. They're genes that, when they function properly, they create a protein that is a tumor suppressor, right? When the genes are not working properly, those proteins don't get created sufficiently, or they're broken, and so tumors grow. And if you have certain defects in these genes, you have a much greater chance of getting breast or ovarian cancer, like 10 times greater chance than someone in the normal population. So it's really important. And the company Myriad, who had these patents, they monopolized the market, which they're allowed to do with a patent, right? But not every patent holder did that. So there were other genes that were discovered. For example, the CFTR gene that relates to cystic fibrosis. The University of Michigan scientists discovered this gene earlier than the BRCA genes, and they licensed everyone who wanted to for a reasonable or a very modest price to perform testing on this gene to screen parents, to screen babies for cystic fibrosis. That was not the case with the BRCA genes or other genes. There's a gene for a disease called Canavan's disease. The thing about a patent is it allows you, it doesn't force you to monopolize the market, but it enables you to if you want to. And if you're a company, it's actually a great business idea. It's like, I've got this patent for 20 years. I can be the only one performing this diagnostic test. And if I'm the only one performing this test, I can charge whatever I want, right? Or I can charge whatever the market will bear. So unlike cholesterol tests or blood sugar tests that you get at the doctor, basically costs $50 or so. The cost of running these tests was probably about $200, but the price was over $3,000, right? And why is that? It's because there were enough people who would pay $3,000 that they could charge that. The problem, though, is that not everybody could afford the $3,000, and the test wasn't covered by all the insurance carriers. At the beginning, it wasn't covered by any insurance carriers. It was not covered by Medicaid, which was a big problem. And there were serious eligibility requirements that to get insurance companies to cover the test, Myriad had to negotiate with those insurance companies And of course, the insurance companies want to pay for as few tests as possible. And so Myriad was able to negotiate that some carriers would cover the test, but in exchange, they also had to agree that there would be strict eligibility requirements, so not everybody could get the test. So to get the test, you would have to be able to show you had like 2 close relatives who died of breast cancer or who got diagnosed with breast cancer below the age of 40 or 50 or so. There are various criteria that, for better or for worse, bioethics, commentators and people had originally talked about because there was a fear of genetic testing in the early days. People, scientists and physicians and ethicists thinking, well, we give information to people, are they going to be able to handle it? Maybe we shouldn't just be giving out this information willy-nilly to protect people in kind of a paternalistic way. That paternalistic protection became something that the insurance industry was able to use to say, well, we agree with these bioethicists. We don't think you should give tests to that many people. And they didn't. And so we end up, at the time this case starts, with a lot of women who should be tested not being able to get tested.
The moral and ethical component of this was critical. What this case, we call this kind of a case impact litigation, strategic impact litigation. What's impact litigation? Well, regular litigation, you hit me with your car, you didn't pay your rent, or you breached this contract, we sue each other. Who wins or loses has no impact on any other person, right? Impact litigation is meant to, as the word says, create precedents that has an impact on many other people. Mm-hmm. And strategic just gives a little bit of perhaps deserved or undeserved credit to the lawyers who came up with the idea in the first place. So as George brilliantly discusses in his book, without again spoiling it too much, we had to make a choice of who were we going to bring impact litigation against. There were lots of gene patents. We could have chosen any of them. This one just stood out from the crowd in both the impact it was having on people. Right, there is some gene patents on deafness, whether someone's going to be deaf. Well, if someone's deaf or not, yeah, that's not great, but they're not going to die.
Right.
This is people dying in their 30s. This is women dying. If you have genetic breast cancer, you're likely to die before you hit 45 or 50. Most breast cancer, 90% of breast cancer is not genetic. It's through what happens after your first cell was created by your parents. It's through mutations that happen naturally through our lives as we get older and party too much on South Beach. And so most breast cancer you don't see until the 60s or 70s. That's not genetic. Genetic is what you see early on. So because this case had a moral and ethical weight that doesn't need to be explained. I don't need to explain to you why one company denying women the right to test their genes to see if they're going to die by the time they're 40. I don't need to explain to you why that's an ethical and moral problem. And that's how we knew, because the law isn't just what's written in the law books. The law isn't just what's written by statute. The law is implemented by human beings who they say they aren't influenced by emotions are, because subconsciously we all are impacted by our biases and our feelings. So we knew critical to winning this case was having an ethical and moral high ground. What exactly, how best to describe that, it's for each person to believe, but that was important. If we didn't have a moral, ethical case, if we couldn't make this interesting for 60 Minutes, which did a story when we filed, if we couldn't make this interesting for the New York Times, if we couldn't make this interesting, the fact that Angelina Jolie happened to be involved, Barack Obama, all these people got involved because it's so transparently, obviously important on a moral and ethical basis, right? Legally, we can debate whether it was legally important, but this is a morally and ethically important case.
Right. Yeah. That's the beauty of the law, right? That it can help us define what those things are.
The law usually lags society's conscience. There was a long time where segregated schools were thought to be legal, right? Until they weren't. And there's lots of things that, So the tale is, the law is usually a tale. It's supposed to be a reflection on the morality of society. In my opinion, other people think the law should lead our morality. I think that risks maligning law with religious and irrational kind of directions. We'd rather stay social efficiency with our justifications.
Definitely. What would the repercussions have been if the outcome of the trial was different?
There'd be no book.
You wouldn't be here today.
We wouldn't be here today.
We're talking about a much more boring textbook that I read.
They tried and lost.
Yeah.
Footnote.
No, I mean, so you can see, I mean, I guess you can ask what the effects of the case were, right? And so they were pretty big effects. So in the BRCA market, like literally the day after the Supreme Court, and this is a big spoiler, right? These guys won their case, right? But that's pretty much on the jacket, so you should know that. They won the case, and the patents on the BRCA genes were invalidated by the Supreme Court. And the next day, competing companies announced that they were going to offer BRCA testing at half the cost of Myriad's cost. And the cost has kept coming down. So that like today, you can get from 23andMe, right, for about $100, whatever. You know, sometimes they're on sale. You can get 23andMe's health indicators, and the principal BRCA mutations are there. And you can find out, for $100 whether or not you have this. That would not have been possible without this case, right? Some of the patents would still be in effect. Some of them, the case happened 2013. Many of the patents would have been expired, but some would still be in effect. So there's that. But the case went beyond BRCA because, as Dan said, this was impact litigation. The idea, and I don't want to put words in your mouth, but was not to go after this company Myriad, but it was to go after the practice of gene patenting in the United States. And that's what happened. So on that day in 2013, when the Supreme Court issued its opinion, all of the patents held by all of the companies, including the ones on cystic fibrosis, Tay-Sachs disease, breast cancer, hemophilia, all of those patents fell at the same time. So in every industry, now in every disease, you could get this sort of testing. And, without this decision, you'd still be in this high price realm where there would be difficult access and so forth to testing.
Yeah, so in reality, we didn't win. We won, we lost again, and then we won. And the way that happened is we won at the district court, the trial court level, and then we went to the Court of Appeals. That same Court of Appeals I told you about earlier, that was home court advantage. Mm-hmm. What do you think happened when we got there? We lost. And the reason why we lost, one of the main reasons, was the judge on the Court of Appeals said there's too much industry reliance on gene patents. And if these people win, these crazy people win, you're going to throw the entire biotechnology industry on its head, and people are going to die. So they've got to come up with a reason why if we win, people die. Right? Because we've got a reason why if we lose, people die. Right. They need to come up with their countervailing people die scenario. And their response was, if we win, all investment in biotechnology and drugs will stop. There will be no new cures for anything. Coronavirus will come. There will not be any vaccines. Right? This is their nightmare scenario. And the reason why I say we lost twice is because when we lost, we then asked the Supreme Court to take our case. And in the intervening period, the Supreme Court had issued a decision in another case, somewhat related to the legal issues in our case. And when the Supreme Court does it, so you're asking them to hear your case, and while your case is pending, they issue a decision in another case that may impact the outcome. They send it back to the Court of Appeals and say, think about your decision again in light of our new opinion in this other case that we think may be related. So we went back to the Court of Appeals and got shellacked again. And all they did, they literally took the exact same opinion they wrote before, and they just added a paragraph saying this new case changes nothing. That's literally, and which someone on the team predicted. I'll let you read the book to figure out who predicted they were going to do that. And so then we finally get to the Supreme Court. And we get to the Supreme Court, and that's where we destroyed the biotechnology, right? The biotechnology industry doesn't exist anymore. People know Myriad Genetics still exists in a very profitable, successful, publicly traded company. You can buy Myriad Genetics stocks today. But at the time, they said, if you guys win, Myriad Genetics is going to go out of business. Everyone's going to go out of business.
It was doomsday.
Yeah. And I teach at the University of Utah. Myriad is a spin out of the University of Utah. It's literally on our campus.
And this is because of that 1980s law I told you
Yes.
that says taxpayer-funded research can be owned effectively by private companies.
Yes, the university got the patents initially and licensed them to a company formed by scientists from the university, right? Those scientists are the ones who want it. But, you can drive up the road in Research Park in University of Utah, and Myriad it literally keeps growing. They keep building new buildings. It's doing very well. And Dan is totally right. The biotech industry is amazing and has done very well. And yeah, but you hear a lot of these "the sky is falling" arguments in this area of the law. Every time anyone proposes anything that's going to chip away at sort of the absolute protection of patents, it's like, oh, that's it. That's the end. We might as well all move to China because, American industry is about to die. And it hasn't happened yet.
Yesterday, you made me aware of the Senator Tillis introduced a bill. Can you tell us a little more about that?
Yes. So this is the epilogue of the story. So 2013, after all of this struggle, like Dan and the team wins this case, Supreme Court in a unanimous decision, right? So I totally spoiled the whole, but it's a unanimous Supreme Court decision here, which, if you know anything about the Supreme Court, right, that's rare. But
If you remember, the last case, the Chakrabarty case was 5-4.
Yeah.
So there have been a lot of 5-4 decisions on this issue. And then our case was a 9-0 decision.
9-0. Unanimous decision. Only Justice Scalia had kind of a snarky 3-sentence concurring opinion saying, I don't understand all this molecular biology stuff. Neither do the rest of you guys. So why are we doing this? But okay, and that's pretty much it. Anyway, that's 2013. But of course, the biotech industry, they are not happy with this decision. And so continuously, from 2013 until literally this week, there have been continuous efforts to get this case reversed. So first, this happened in the courts, right? There were Myriad, a few months after it lost at the Supreme Court, it brings some more cases against these companies who entered the BRCA testing market with some other patents that actually weren't at issue in this case because they had tons of patents and there were some exceptions in the language. They lost. They ended up losing those cases. There were other cases that were brought. They all got lost. So the courts were obviously going to stick with the Supreme Court's decision in this case. But that's not the end of the story, right? If the courts don't agree, you can go to Congress, and Congress can change the law. And so that's what the industry tried to do. So starting in 2016, there were efforts to get the patent law changed. Those didn't work. 2017, 2019, none of this worked, but, continuous pressure. We kind of took a pause during COVID-19, right? But now we're back, and 2021, the pressure started again, and literally just this week, a couple of days ago, Senator Tom Tillis, who is the ranking member of the Senate Intellectual Property Subcommittee of the Senate Judiciary Committee, introduced a bill that explicitly says you can get patents on human genes that are isolated and purified, right? The ones that are taken out of the body, exactly reversing the Supreme Court's language in this case. And, who knows? A lot of bills get introduced in Congress. A lot of stuff happens as the sausage gets made. But it's clear that the industry is still not going to rest, right? This is still a live issue. And, we're back again. This coming session of Congress, this stuff will get debated again. And when this happened in 2019, very similar legislation was introduced, the ACLU, that gathered up all of these advocates, Nobel laureates, and other people who were opposed to this and killed the legislation in 2019. 2022, we'll see what happens. I've already written a blog post about this, and it's never a dull moment here.
So legal political economy tells us that the easiest kind of law to get passed is that which benefits a small group and harms a large group. Why? Because the small group that's going to benefit can go and lobby and spend lots of money whining and dining in K Street and all that kind of stuff. And the people who are harmed, they're so diffuse and so numerous, we have a prisoner's dilemma or collective action problem. Who's going to stand up amongst the 330 million Americans that are going to be harmed, as opposed to the 45 or 50 biotechnology companies that are going to be benefited by something like this. So that's why legislation is not usually a solution for problems that are impacting society at large and benefiting a small special interest or lobbying group. So this is typical DC stuff, and I'm sure it's Tillis making money, saying he'll listen, and I don't know. He has no patent background. Everything he says sounds like it's verbatim from industry talking points. Like he literally just takes their Word document and publishes it as his own. So I have a little bit of a personal problem because a former client of mine is another nonprofit that's attacked drug patents on drugs. And Tillis sent them a letter recently saying that they were publishing false information, which is a slanderous accusation. So, I don't know why I went on that rant. Here we are.
No comment.
No comment. No comment. Yeah.
We don't like this guy. He sounds like he's no good.
I guess I would say I don't respect him enough to not like him.
Okay, I'm gonna start using that line.
He's just not thoughtful, right? Assume I'm an idiot. Assume I'm a congressperson, but I repeat myself. Anybody know that quote? Somebody knows that quote. Mark Twain.
Yeah, I've heard that before. Of course. To lighten things up a little bit.
I forgot we have a 9-year-old in the room. I'm sorry.
He's
I'll
one
bring
of the
my language
brightest
back
9-year-olds
up.
you'll ever meet. So
No, I testified.
I understand all this.
Oh yeah, great. Fantastic. So George and I both testified in front of Congress. I think I'm the only one between us who actually got laughed at by a congressperson. And I said we shouldn't automatically grant patent holders injunctions taking products off the market. And he just laughed.
I feel like I would do that.
he probably laughed because he didn't understand. It's a nervous, it's a response. Yeah. So one of the biggest victories, besides all the implications this case had, I would say, was to showcase our legal system. And even though it has its flaws, we have a very special one, right? Because we can make changes. You make changes. What do you think about that?
Yeah, so taking a step back from this individual case that we talk about in the book is sort of another story about how the legal system works in this country. And it's very unusual, right? It's the legal system we inherited from England after independence. But not that many countries have a system like this called a common law system, right? Where in most countries, you go to France, you go to Germany, you go to China, Japan, the laws are made by some legislative body or political organization. Bureaucrats basically write the laws. And we have some of that. We have the tax code, no offense to CPA. The tax code is a very bureaucratic body of law. But most of our law, or much of our law, is common law, meaning judges make it and courts make it. And when a court makes a decision, right, other courts below it have to follow that decision, right? So here, the federal district court in Miami makes a decision. Well, the federal agencies in Miami have to follow it. If it goes up to the 11th Circuit, then all of the, courts and people in Florida and other states in the 11th Circuit follow it. U.S. Supreme Court, everybody in the country has to follow their decisions, right? So judges and courts, these individuals actually make these very important decisions, and they do change the law, but they change it in response to individual lawsuits, right? So all those years that nobody was challenging gene patents as a practice, the law wasn't going to change. But when somebody did, when somebody figured out something that was wrong that we should change, then they could, right? They could change it in a way that doesn't require going to Congress, right? Going to Congress is a very specialized thing. And, Dan refers to K Street. This is where all the lobbyists have their offices. Generally, ordinary people don't have access to lobbyists who know all the Congress people and more importantly, all their staffers and can get legislation passed, right? But anybody can go to court. And for relatively modest filing fees, right, you can bring your case. And the result of that is like every person in the United States has the right to go all the way up to the Supreme Court. And you can do that. And that's what happened here, right? Ordinary people represented by, great lawyers, but no legal fees got paid in this case, right? I mean, there was nobody, this was a pro bono case. So the patients, like there were 6 of the 20 plaintiffs here were individual patients. They didn't pay legal fees here. They just, got involved. They supported the case. And it was brought, and this is, it's really unique that in this country, ordinary people can get together. They've got to have good lawyers who are willing to support their cause, but they can get the law changed, which is a really amazing thing.
Mm-hmm.
The system works if you work it. Right? But you got to work it. It's not going to work if you don't work it. It takes people participating and being involved.
Thank you. That was such hopeful insight because we, right now with everything going on, we always focus on the doom and gloom, of our system. So it's great to hear you say that. As technology advances, what measures do you think it can be implemented to make sure that these things don't come up in the future?
Well, you just can't predict, right? I mean, law, as Dan said, law kind of lags sort of moral understandings. Law also lags technology, right? We just struggle, right? The law is reactive. We try, like Congress tries, the executive branch tries to sort of predict what's going to happen with technology, but we're always wrong, right? We're never able to predict this accurately. And what the technological issues are with artificial intelligence, autonomous vehicles, autonomous drones, surveillance, there are hundreds of these technology issues that we know are coming. We have very little idea how we can and should handle them. Trying to be proactive about it, we could, it often doesn't work very well. And we end up having to change things. So, like we see that with patenting of genes, it seemed like a perfectly reasonable thing to do, at the beginning when you're talking about an oil-eating bacterium. And look where it led us. Right? So, I don't know, maybe that's not very hopeful.
Yeah, there's a large, the biggest change to patent law in 60 years was passed in 2011 by Barack Obama and a Republican Congress. The one thing Barack Obama and a Republican Congress could agree on was reforming the patent laws. And it was spearheaded by the technology industry that had been repeatedly sued by these shell corporations that have no business other than owning patents and suing people. And there had been a lot of verdicts in Texas against Microsoft and Cisco and Google and all these big tech companies, Facebook, for tens and hundreds of millions of dollars. And as a returning the favor for all that the tech industry did for Obama, one of the things he promised he would do is change the patent system. So this 2011 law, which was called the America Invents Act, has had the effect of reducing the value and strength of patent by at least half, if not 2/3, in that it did lots of things, but the main thing it did, it created a new process where any member of the public can challenge a patent at the patent office without proving that you were threatened. So one of the issues we had in this case was in order to go to court, you have to have what's considered constitutional standing. You can't go to court and bring a case just because you don't like someone. They have to actually be causing you concrete and immediate harm to you. And these standing lines of cases have gone throughout decades of litigation about people trying to bring environmental cases. Well, how are you harmed if we build that dam and it kills off all the frogs and birds and snakes? How are you harmed? Right? That's one of the biggest standing cases. So when you can bring an administrative action to have the patent challenged, you don't need standing. And that was one of the important things about this new law. So the ability of the public to access and participate in our legal system directly relates to how well the patent system maps on to the needs of society as a whole. Basically, whoever is allowed to access the legal system dictates who will benefit from the legal system, right? Sounds right? Whoever we let in the door is going to make sure the system benefits them. So if we only let in the door large corporations, we can naturally expect that the law is only going to benefit them, right? You know? And so the more we can do to create access to justice, access to the legal system, be it at the court level, the administrative level, the legislative level, or the executive level, the more the public's will be expressed. So generally speaking, the more that the public can participate, the better it will be.
Right. Before we open the conversation to our audience members for questions, so you guys can start thinking about what you would like to ask our amazing experts. I want to congratulate you obviously on the book and on the case. The book was such an easy read. You're able to bring in so many interesting pop culture references and just really take this, no offense, really boring stuff and really update it in a way that anyone can read it and relate to it and understand why it's important. How was the process for writing this?
It was a huge amount of fun, I have to say. And by the way, the book does have pictures, so
And there's an audio book version.
There's an audio version. And there's a picture of Dan and Angelina Jolie. They're both.
That's right. They're both in there.
Same,
I had to pay to use the picture of Angelina Jolie. Dan, thank you. With Bryce. But in terms of process, so, I'm a law professor. My job is essentially to write boring things, which I do in huge quantities. And this was a totally different type of writing project, right? And I did it. I started by interviewing people. I started back before the Supreme Court case by talking to the cancer support group, FORCE, right? Facing Our Risk of Cancer Empowered. This is a support group for people with BRCA mutations. And I did a focus group in Washington, D.C. with a number of these women. And the stories that I heard from them were just so incredible. I thought, wow, like there's really some human stories here behind all of these legal doctrines and political economy discussions, right? Which are interesting to economists and political scientists and lawyers, but don't make for a really interesting story for a general audience. And I thought this case is an important case, and I wanted a general audience to understand it. Like, you probably don't know this, but there are tons of academic articles about this case and these issues. But you probably don't want to read, and several by me, right? But you don't want to read any of this. The book is intended for a general audience, and it's about the people who were involved. And so I thought I've got to sort of put aside my law professor hat and become an investigative journalist. And that's really with like zero training. That's what I did. And I read a lot of these journalistic books about law, non-criminal law cases, like a civil action, which involved a law firm that I was actually a partner at before I became a professor. And so I knew about that book and what Jonathan Hard did to write it because our firm was involved when the movie got produced, and made sure that the movie wasn't portraying our firm in an inaccurate manner. And so I knew that the sorts of things I had to do. And so I interviewed like nearly 100 people for this book. People like Dan, right, who were like very generous with their time. The ACLU lawyers, but also the patients who were involved, scientists, like some of the judges, their clerks. Like, for those who don't know, law clerks are like the lifeblood of any court. and just everyone who got to find who was involved. The people in the government, we haven't really talked about the Obama administration behind the scenes in this case, which was this crazy sort of Alice in Wonderland rabbit hole that I kept getting deeper and deeper into. And literally I would have a conversation in like a tavern in Washington, D.C. with somebody who says, oh, you've got to talk to so-and-so because he'll tell you the real story about what happened here. And there was this huge internal political conflict within the administration between the people at the Patent Office and the Department of Justice and the National Institutes of Health and the Office of Science and Technology Policy and the White House and like some of the senior advisors in the White House. And so I just kept interviewing people, I was actually based in Washington for part of this time. And then I moved to Utah, totally at random.
Back to Myriad.
And I ended up in Myriad's backyard. And then I could interview the Myriad people. And I thought I wanted this book to present both sides, right? So we've heard a lot about the ACLU and Public Patent Foundation's side of the story, which I am sympathetic with and which I agree with. But I also wanted to present Myriad's side of the story because, at the end of the day, they're not evil people. They were acting like a biotech company would act. And the patents, they were legal patents. It's not like they were stealing money from somebody. They were getting patents issued by the United States government. So I wanted to hear their side of the story, too. And I was able to get some very nice inside access to people at the University of Utah and the company as a professor at the University of Utah. So, I had thousands of note cards and notes that I, tried to weave together into some sort of story about the people who brought this case as opposed to just the abstract legal issues. And, it was a lot of fun for me, and I hope it was a fun and interesting read.
It was. I really enjoyed it.
Just so everyone knows, the reason why this internal government debate was so important. So in about a third of Supreme Court cases, the United States is a party. Right? And the Department of Justice is just the law firm for the United States. So that every lawyer that represents the United States works for the Department of Justice. So about a third of Supreme Court cases, the United States is a party. About another third or so, the Supreme Court, even though the United States is not a party, the Supreme Court asks/demands that the United States stick its nose in and tell the Supreme Court what they should do. And so the United States come in as kind of like a third party advising the Supreme Court what to do. And their advice is most often taken. Very rarely will the Supreme Court disagree with the Department of Justice. At least two, I think, justices are former Department of Justice officials. Mm-hmm. So, they take a lot of respect for that. So how the Department of Justice came out on this case was, again, another critical factor. If they came out completely on the side of biotechnology industry, these are crazy communists who think companies shouldn't own anything and we're going to have no incentives, that would have been devastating. If they came in on our side, that would have been influential. Doesn't mean we couldn't have won if they came in against us. But I'll leave it to you to read the book to figure and see how did they ultimately decide. And it's not as simple as they were with us or against us.
Yeah, it was a complicated thing, complicated set of negotiations, and trying to wheedle this information out of former and existing government officials was challenging, but also a lot of fun.
Would you like to see this book take life in a different form, like a movie or a TV show?
Sure. I will give you contact information for my agent. Anybody out there, representing HBO or net, just let me know.
With Angelina Jolie.
Oh yeah, absolutely. Yeah.
That's Barack Obama over here.
All other letters.
Yeah. Well, I've already got Jason Momoa lined up for me. You can tell why.
Yes. Yeah,
So a little bit of inside intel. So we actually had members of our team meet with Brad and Angelina more than once to try to convince them to come out in support of our case. And hearsay, unconfirmed, the PR handlers would not let her. They said, you cannot do this. You'll lose sponsorships, you'll lose your brand, you'll burn bridges. So the most they would let her, I encourage you, if you're interested at all, go look up her op-ed in the New York Times.
I remember that.
Mm-hmm.
And she drew as aggressive a line as her people would let her. And so she didn't come out and say the ACLU and the plaintiffs in case should win, but she did raise some of the concerns. And I think ultimately that was a good kind of trying to strike the balance between the two interests and not saying one side's good or evil. This, both sides can have good, but we still need to make a decision here.
She raised awareness.
Yeah,
For sure.
she definitely helped raise awareness. I remember
And-
that op-ed and that conversation.
And her op-ed came out literally while the Supreme Court was considering this case, right? There were a lot of incredibly savvy PR moves that you guys made in the case that completely flabbergasted the other side, right? Because patent cases, they don't involve a lot of PR movie stars, 60 Minutes episodes. There's a handful of experts who follow them and find them very important, but the general public is so the other side, even there were excellent Supreme Court litigators, one of the biggest firms in the United States, it's like they never saw any of this coming. It was a complete surprise. So
Another little interesting factoid. Sonia Sotomayor's ex-husband
oh no.
is a patent attorney largely for the biotechnology industry.
He's and not just a patent attorney, he's one of the primary patent bloggers. If you read the book, you probably, the patent blogosphere is a crazy thing. So vehement, and he's one of the, he's actually a friend of mine and a very nice
He's a good guy.
Very smart, and one of the more level-headed bloggers out there in the patent blogosphere. Good guy. Yes, but former husband of Justice Sotomayor, who compared gene patents to making chocolate chip cookies, if you're interested.
And just trivia, let's see how smart the audience is. There's one Supreme Court justice who more often than not writes all the patent opinions. Anybody know which Supreme Court justice it is that generally writes the patent opinions?
No, it's not Clarence Thomas.
It is Clarence Thomas.
Really?
Clarence Thomas is the patent guy on the Supreme Court. He wrote this decision, he wrote several other decisions.
Nice.
The theory is, and I won't disclose, but I did interview some clerks on the court, and the theory is his views are so controversial that often even the other conservative justices don't agree with him, unlike the politically charged cases. So they're not going to let him write the majority opinion. But no one really cares that much about the patent cases. So every justice has to pull his or her weight, right? They've all got to write some opinions. That's part of their job. So they give them stuff like the patent cases
They
that,
throw in the cases.
that they kind of don't care as much about.
And the funny story about Thomas, I know we're running late, sorry, but I hope people are enjoying this. So at counsel's table, I actually was sitting right in front of Clarence Thomas, and the room is kind of small, so Clarence Thomas is sitting right here where you are, sir, but they're on a bench that's about this high. So I'm sitting and the wood comes out, so he's leaning back in his chair. I can't see his head half the time. And he just said, at the time he never asked questions. This was before he started asking questions. So he just sit there rocking his chair, and the whole time I know, you're writing this opinion. I'm not really looking at anyone else. I'm just looking at his reaction, and he's like, I don't really like what's going on.
That's
That's
what
awesome,
an
isn't it?
experience.
I haven't had a chance yet, but I do want to thank Jenny for hosting us.
Thank you guys for being here. Thank you all for coming. And I actually want to take a second. George, you brought it up a couple minutes ago. FORCE, the Facing Our Risk of Cancer Empowered group, one of the NGOs the case was involved with. You are so generously donating half of the proceeds from this book to them. So we just want to make you all aware that that's happening, and we'll also have the link in our socials and attached to this episode for those watching in the future, so that you'll be able to make those donations if you are so inclined. But we really want to thank you in advance if you choose to do so, and say that we appreciate it very much. We are ready for questions, right?
Sure.
So we'll start over here.
So this is fascinating, and thank you very much for being here. I'm actually encouraged by photographs, so that's great. My question really is two parts. I understand that the appellate reversal was based on a sort of commercial, downstream, societal impact. My first question is, what type of arguments going forward do you think would be successful? Actually, it's really one question. What do you fear would be the most successful challenge at this point?
So an interesting thing about this case is that sort of the arguments and the reasoning occur at different levels, right? All of this political stuff, the stuff about the patients, the cost of healthcare, access to healthcare, the industry, like all of that, the courts talk about, but it's really kind of irrelevant, right, to the decision. The case is really about this very narrow doctrine of patent law called the product of nature doctrine. Is that gene something that occurs naturally, like a new plant that you find out in the jungle? You can't patent that. Or is it an invention, right? That core question, and there's a lot to argue about, right? And you know, we haven't talked about the Federal Circuit, the appeals court's actual reasoning, which was they view this as a matter of chemistry, right? Not a matter of biology, not a matter of genetics, not a matter of industry or the economy, but of chemistry. And as a matter of chemistry, you know, when you take that gene out of the chromosome in the cell, you break covalent bonds. I don't know if any of you remember any of this stuff from like high school chemistry, right? You break a covalent bond, you change like water into hydrogen gas and oxygen, right? It's totally change it. And so when you do that, like the chief judge on the panel that heard this case, he had a PhD in chemistry. You know, he had worked in the pharmaceutical industry as a pharmaceutical chemist for years before he became a judge. And, you know, because this court, this appeals court, was so focused on patents, it's nicknamed the patent court. And of course, who wants to be a judge on that court, right? A lot of patent lawyers. And so it's very focused on that. So the argument, this product of nature doctrine, is still a pretty good argument. And I think it should still be a winning argument. You shouldn't be able to patent something you just find out there in the natural world. It's got to be something that you invent. And, you know, that fundamental legal question, it gets swamped by like the bigger social and political questions that revolve around this case. And honestly, I think the way our legal system works, and again, this legal realists have thought this for about a century, is like judges figure out which way they want the case to turn out, and then they backfill the legal reasoning. Right? You could construct this product of nature doctrine to come out whichever way you wanted in terms of the larger. So and this is why things like Angelina Jolie and this being breast cancer instead of some rare disease that nobody ever heard of were very important for framing the case in the mind of the courts and the judges. But, you know, I would say you've got that legal argument. We also haven't talked about public health. Because this question is not just about human genes, it's about all genetic sequences, right? So the SARS-CoV-2 virus has an RNA sequence that was determined like back in December of 2019 when this outbreak first happened. The scientists who found it, they immediately posted it to public databases. And so scientists all around the world were very rapidly able to analyze this thing and all of the we know just about Delta, Omicron. There are hundreds of thousands of variants in that SARS-CoV-2 virus. And they're all in public databases, and nobody patented any of them, right? That wasn't the case before. When we had the original SARS, when we had MERS, when we had H5N1, in all of those cases, which were in sort of the early 2000s and 2010s, there were groups trying to get patents on those sequences, and that was a problem for global research, right? It was a pain in the neck, and luckily none of those outbreaks were as serious as COVID-19, but they could have been. And so I think this public health element is new, right? This did not exist at the time this case was brought. But this is a new aspect of it that I think is really important for us to think about. Like we want when COVID-23 shows up, we want researchers around the world to be able to act very quickly, come up with vaccines again. And, if you've got to go negotiate a license agreement with some university or company who holds these patents, who might not even want to let others access it, it's a problem. So that's the argument that I like.
Getting a little bit of legal minutia, if you've got competent lawyers on both sides, which most of the time you do in federal court, not so much state court, but in federal court you usually have competent lawyers on both sides, you've got enough evidence and legal reasoning to support the judge deciding whichever way she wants. So it does come down to kind of this either the subconscious or whatever inkling she has. So because it's a lot of in the eye of the beholder, what we do, like when we go up on the Court of Appeals, there's 12 active judges and 3 senior judges, and we will map out for the legal issues that we're arguing, because you don't know which judges you're getting until you show up for oral argument. We'll map out which cases, which judges like and which ones they don't like. And so once you know which 3 judges, you would tailor your argument to, so like the judge who was the most senior judge on our case, the former GlaxoSmithKline patent lobbyist, was one of the first judges appointed to the court. We knew Judge Laurie was going to rule against us immediately. Bryson was one of the other 3 judges. He was not a patent person at all. He came from government. So we knew, and he actually dissented. So he would have sided with us and affirmed the district court. And then Moore, the third one, a former law professor who taught patent law and went on the court. Like George says, you don't go be a judge on the patent court because you hate patents, right? You're there to make patents.
Another question. Thank you for bringing up the public health aspect. I'm a professor at the University of Miami in biostatistics and public health. Following along your lines of product of nature, where do you fall out, or where does the law currently fall out when it comes to something like CRISPR and gene editing?
Yeah. So I'll give you my opinion. These cases haven't come yet. They're still fighting about who owns the CRISPR patents, right? But once that'll get settled within the next year or 2, and then we'll have patents there.
Just for those people who don't know, CRISPR is a new technology in which your genes can be edited. So up to now, we can only read someone's genes and then look up in a database whether they're good or bad or may cause a problem. CRISPR is actually an invention which, if we know you've got a problem and you should have a C instead of a T, we can just go in and fix you.
Yeah, so there are 2 ways that you can edit. Or this isn't possible in humans yet. The one attempt in humans with the Chinese CRISPR babies was kind of a failure and sort of an ethical problem, to say the least. We won't go into. Other people have written excellent books about that. But someday CRISPR will be a viable, safe technology that we can use. And there are going to be 2 sort of methods that we can use. So researchers can come up with a new sequence from scratch, right? They can say, it would be really good, like we've analyzed the chemistry, we think that we want people to be immune to cancer, and this is how we're going to do it. We sort of call like rational drug design, rational gene design. And then that's like Chakrabarty's bacterium, right? It's something new that didn't exist before. We're just going to create it, and it is going to be patentable. Much more likely, at least in the near term, is we're going to, we've got sequences from all of these different people, and it's like, hey, lo and behold, there are some people who don't get COVID, even though they're in these crowded rooms, this party, they're sharing beverages with all kinds of sick people. They're not getting it. Like, why is that? Well, they've got some special variant in one of these genes, and we figured out which one it was. And now, you know what? Everybody should get that. When you get a shot, everybody's going to get that. That existed in nature, right? So that's a naturally occurring sequence. That would not be patentable under the tests that we've got in Myriad. So, I think for pure synthetic biology, that's a matter of engineering. And yeah, I think you probably still are going to be able to patent that, but not something naturally occurring that even could be very helpful.
Well, and patent law allows you to patent both things and methods. And as a patent attorney, I would tell you, you never want one patent, because everything can be subject to a method and every method can involve a thing. So you should always have patents on both the thing and the method at minimum. So there's a whole another set of cases that the Supreme Court issued relating to methods. and whether that it implements a law of nature. So the parallel cases, like Mayo and other cases, say you can't get a patent on a law of nature, whereas our case was you can't get a patent on a product of nature.
You have a question over here?
Hey, so thank you guys so much for being here. I'm really excited to read the book now. My question's a little off topic, but it's kind of springing off something Dan said that I found really interesting. You said the easiest laws to pass are the ones that benefit a small group of people and harm a large group of people. And the way you framed it made a lot of sense. You know, a small organized group of people that's able to, play the DC game, K Street dinners, and, get their agenda pushed through. I was just wondering if maybe off the top of your heads, if you had any other examples of that happening beyond just biotech?
We just passed semiconductor subsidies, right? We're giving billions of dollars to semiconductor companies, which are run by executives that make tens or hundreds of millions of dollars a year.
Yeah.
Why are we doing?
Yeah.
The environmental space is notorious for this happening. The oil industry is extremely powerful. And we've just had this term an important Supreme Court case that's severely going to limit, how federal agencies can regulate environmental pollution and so forth. It is a game of, again, we're all affected by environmental issues, but there are just a few nonprofits, right, who litigate these as opposed to a trillions of dollars industry that is on the other side.
So just go to the derivative of that theorem that I gave you. The derivative then is, how do you stop that kind of litigation? How would you think you would stop it? I've got litigation that really helps a small group, it hurts a large group. How do I politically stop it from passing? I've got to come up with anecdotes of specific people that are harmed by it, right? I've got to come up with my corollary poster children, right? And so once I come up with my corollary poster children, I can now combat. So I've got to find a special interest somehow that's being harmed by it.
I assume that the DNA.
Sorry, I think they need
Oh.
the mic.
Just so everyone
I
can
assume
hear
the
you.
DNA analysis also applies to cells. So my question is about Henrietta Lacks, and maybe that's why she can't get a lawyer, or if she was alive.
Oh, she's got a lawyer.
But I mean, oh really? Is there in litigation?
There is litigation brought by her state against
Okay.
Johns Hopkins and
Do you want to tell
I think
people the story? Who are
Thermo
familiar?
Fisher. Yeah, do you believe? We know the story.
No, you'll do it better than I do.
I mean,
I just watched the movie.
So another one of the models for this book was The Immortal Life of Henrietta Lacks, which is a 2010 book by Rebecca Skloot, which is an excellent book, which I highly recommend. Another sort of law and science tale about a woman named Henrietta Lacks, poor African-American woman from the South who is sick, goes to Johns Hopkins Hospital, which has sort of a pro bono clinic for indigent people up in Baltimore, is diagnosed with cervical cancer, is treated, but dies from her cancer. And but the thing and this story is a story that's referred to millions of times, the thing that's unique about her is that in her biopsies that were taken of her cells, which was done with every cancer patient, right? After her death, it was noticed by Hopkins researchers that, like, oh, this petri dish of cells, like, this is kind of strange. Like, these cells are still alive, and in fact, they're growing. And so it turned out that there was something very special about her physical cells. They did keep on growing and growing, and they are what became known as an immortalized cell line, and this was something that, other scientists then grabbed onto and found to be very useful. Like, why is this? Well, because when you're testing a drug or a compound for toxicity, or you're testing, chemotherapy to see what it does with cells, you want to test it on a cell line that is comparable to what other scientists are using in other labs, right? You want a constant. So you say, in these particular cells, my compound did this or did that. So the cells eventually got acquired by a company, and they grew them and grew them and grew them, and they became sold as a standardized cell line called the HeLa cell line, HeLa for Henrietta Lacks. But nobody knew what HeLa even stood for. You could just go to a chemical catalog, and you've got a new cancer drug. You're gonna, you buy some HeLa cells to test them out on. Then you report your result and say the HeLa cells survived, didn't survive, were reduced by 25%, whatever. So this all happened. So her case happened in the 50s. But the HeLa cells became like the most popular reagent cells used in biomedical practice right around the world. They're all over the place. Every lab who's testing any kind of compound uses HeLa cells. And nobody knew that they came from this woman, Henrietta Lacks, until this was discovered through a long, circuitous set of events. You should read this book if you haven't, to see how this all happened. And so the question is, does this multi-billion-dollar industry owe anything to Henrietta Lacks's family, right? Because they were literally her cells. And it just in the last year or so, there is a lawyer who took on this case, who's suing Thermo Fisher Scientific, which is just a big scientific equipment and chemical company, to get some of this money. It's a very complicated set of legal issues. The statute of limitations issues, right? This is 70 years later, so who knows if these claims would even still be good. But beyond that, there are questions about property, right? So you've got other cases from California, very famous case involving a guy named John Moore, in which the California Supreme Court held, look, once you're undergoing a medical procedure, like the stuff that comes out of your body, that's waste product. So like you're walking down the street, you spit out a piece of gum on the street, you've got some saliva on that gum, you've abandoned that property, right? It's like you throw away a can of Coke in the recycling bin. You used to own it, you bought the Coke, you paid whatever, $5 for it, whatever it cost today. You abandoned it, so it's no longer your property. So somebody can come along, grab your can from the recycling bin and, return it for a nickel or sell it to a recycling company, right? That's fine, it becomes their property. What about those cells? And what about all the waste biomaterial that comes out of us when we go to the dentist or, the doctor, like you give a blood sample or a urine sample. Generally, you don't consider yourself to still have a property interest in that stuff after you've given it away. So the legal question with Henrietta Lacks's case is, did she just give that away, or does she have some property interest that she retained and her estate retains in those waste cells, right? Those biopsy cells. And this is a live question. California Supreme Court said, no, you don't. You don't. You give it away, it's gone. And there were a lot of policy arguments that came up. That was a 1990 case in the Supreme Court of California. It said biomedical research would come to a halt if we let people, own all of the stuff that comes out of them in the hospital. Like what you went to get your treatment, as long as you get your treatment and you're treated ethically, which this guy John Moore wasn't. But assuming you are, you don't own it. But Henry Lacks's case is being brought in Maryland court. Maryland court does not have to abide by the California Supreme Court's decision. So, open question. That this could be the next book. Like who? It's a live question.
This is why every time you go to a new doctor, they make you sign all those forms.
Oh, yes.
It's the consent form. Every time you go to get a procedure done, you sign those consents waiving all your rights to.
Yep. People have learned their lesson.
Hi, it's a pleasure to be here, by the way.
Thanks for coming.
Thanks.
Also, thank you for the recognition of court clerks. My sister actually is one, and for people that don't know, court clerks are the legal system would essentially fall apart without them. It's kind of like the nurses or the receptionists in a hospital, so that's how they function. And the reason I took such an interest in this in particular is because I actually just finished reading this year. I read Empire of Pain, and it pertains to patents. It's not the main focus, but it is important.
And this is the opioid.
Yes, exactly. And then after that, I read Painkiller, which is another book that was published in 2004. It's a little less recent. That also pertains to the patent of oxycodone and its relation to the current opioid crisis.
I litigated the oxycodone patents. Some of the tamper-proof, which wasn't really tamper-proof.
Yeah. So my question was actually pertaining, I know you guys mentioned the 23andMe testing and such, and you know how they've now become very common and people, you know, that you can buy them at the store and, you know, use them. And I guess my question is, do you guys foresee, I know there have been some debates about what information is, you know, as far as is allowed, right, to be sold to corporations after people take these tests, like what you just mentioned. So I guess my question would be, do you have any predictions about what the future holds as far as legal cases that may come up pertaining, or that are maybe current that we may not know about?
Your rights and your genetic information are alienable, which means they can be contracted away. So whenever you buy these genetic tests, they have all the language in there that's boring and nobody reads that says you're giving them the permission to use your genetic information in certain ways. And those license agreements, when they get published, sometimes they're controversial and people will push back on them, especially like academics and other policymakers. And there's been some attempts to have industry norms for what's cool and what's not cool to do with people's genetic information. And there's been proposals in Congress, maybe there should be a statute that says customers or consumers cannot give away certain rights to their genetic information. But those bills, because they would benefit a large group and harm a small group, never see the light of day.
Well, it's like what you guys mentioned before, that like the law tends to always lag a little bit behind whatever the technology or the innovations are that are going on within the biotech industry. Thank you.
Have you taken or would you take one of those tests?
Yeah. And my dog, yeah.
I mean, if somebody's interested in this area, I've taken them all, right? I've done Ancestry, I've done 23andMe, I've done the National Geographic one that's like now out of business and probably has sold its stuff to whoever. But I'm just totally curious about it, and you know, I'm very comfortable with, you know, if people can make a drug out of some information about me, I do it. You know, I'm all for it. I want that drug to be made. Right. I think the information you get is fascinating. And it is interesting, though. So 23andMe and some of these companies they have started to become more and more careful about what you have to fill out more and more consent forms each time, right? because they are hearing concerns like this. And part of this is a PR issue as opposed to a real legal issue, right? They want people to feel comfortable with their service because still it's only a small minority of the population who's signed up, right? They would love for the entire population to do this, but to do that, you know, to get more customers, they're going to start to need to be more trusted, and so I think for public opinion is pushing them toward, you know, asking more, or even if they don't have to legally. I've noticed just more and more consent forms, and you know, I always just click without really.
This month we're actually going to. So generally the public's access to technology works on a step function, not linearly. And what I mean by that is when the new iPhone or a new drug or the new website comes out, it's not slowly dripped out to a small number of people that increases over time. It's immediately available to millions of people. So it's a step function, right? The number of people available, it's a step function. This month, we're actually going to go through another step function that increases our access to genetic testing, because to date, there's been only one company that's allowed to actually sell the machines that can read your genes. So when they take the blood or saliva or whatever, that no one can look at it with a microscope. There's got to be a really, really high power sequencer. And there's been one company called Illumina out of California that has had all these patents, portfolios of patents around their sequencing machines. Well, those patents expire this month. So starting this month, Illumina is going to start having competition for sequencing. So the cost of sequencing your gene, which means just reading your gene, is going to dramatically fall. So just keep it in the back of your mind and see if you don't see more genetic testing products, more genetic testing at your medical providers at lower costs within the next year. All because in this instance, it's what we call a patent cliff. The patent expires, there's a cliff, competition immediately rushes in, and we see these public benefits that mature once the patents expire.
Who had the next question? I'm sorry. Oh, okay. Sorry, I misunderstood. Any more questions? Anybody? No? Okay, then thank you guys so much for your amazing questions. Thank you, gentlemen, for being here all the way from Utah. And welcome back home. And on such a special day on your dad's birthday. Thank you, Dan, for sharing so much with us. I want to thank Books and Books, and obviously you guys for being here. For those of us, not those of us, sorry guys, my coffee hasn't taken in. For those watching at home or listening, or both, thank you so much. As we always say, time is a top currency, and we are so grateful that you chose to spend it with us. Make sure you check out the book. Those of us here, the book is available in this side of the bookstore, and these gentlemen will be more than happy to sign it for you and take some pictures and just continue the chat. So thank you again.
Thank you.
Chase your